Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, about a month ago, we did this video right here where we talked about this great concern that we had with New Jersey's new law as it related to firearms that did not have serial numbers, because that law made possession of a firearm without a serial number unlawful. But the big problem was actually how New Jersey defined firearms, because it wasn't what you and I might think. It was just about everything. So it led this channel and many other people out here in the YouTuberverse to start talking about how New Jersey was basically about to commence with the largest gun grab in the history of the United States. And had New Jersey enforced its law the way it's written, that's exactly what would have happened. It appears, in a rare moment of common sense and human decency, the Attorney General of New Jersey has changed his position and has issued a memorandum on what this enforcement means. So let's get everyone up to speed, especially the good folks in New Jersey, and let's talk about how New Jersey appears to be backing off the biggest gun grab in American history. Okay. So this is what we're talking about today, is New Jersey Statute 2C 39-3. That statute made it unlawful for any New Jersey resident to possess a firearm that does not have a serial number on it, which was put there by the manufacturer. You sit there and say, okay, well, there's a lot of states that have laws like that, Washington State being one of them. That is absolutely true. Here's the problem for New Jersey. Their definition of a firearm goes well beyond any other state's definition of a firearm. In fact, it stops just short of a slingshot, okay? And so there was all sorts of antiques, curios, relics, BB guns, pellet guns, all of these things that normally none of us who have even a rudimentary understanding of guns would ever include to be a firearm. But the state of New Jersey, because they know better, they actually included it. This led me and several other people out here in the YouTuberverse to start talking about how New Jersey was about to commence with the largest gun grab in the history of the United States, which, if they followed the way their law would have been written, is exactly what would have happened. However, in a rare moment of common sense and human decency, the New Jersey Attorney General has issued a memorandum saying, hey, hold on second thought, this is how we want to enforce the law. I'm going to read parts of the memorandum for you so that you can understand, especially those of you in New Jersey, what your legal obligations are and are not at the current time. The pertinent portions of the memorandum read as follows. There has been some question as to, 1, the meaning of a firearm manufactured or otherwise assembled using a firearm frame or receiver, which is not imprinted with a serial number registered with a federally licensed manufacturer as used in NJSA 2C 39-3 and NJSA 2C 39-9, and 2, whether it may be read as extending to various categories of firearms that are not required by federal law to bear a registered serial number, including firearms that use air, carbon dioxide, or springs to expel a projectile, such as pellet or BB guns, antique firearms, and firearms manufactured before 1968, when federal law first began requiring that firearms be imprinted with individual serial numbers. So, this memorandum applies to firearms that fall into one of those 3 categories, and that's important, okay? It only is firearms in those 3 categories. The Attorney General goes on to state, significantly, the definition of firearm is more limited under federal law than it is under New Jersey law, and includes only A, any weapon including a starter gun which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, B, the frame or receiver of any such weapon, C, any firearm muffler or firearm silencer, or D, any destructive device. Such term does not include an antique firearm. Accordingly, federal law does not require firearms that use air, carbon dioxide, or springs to expel a projectile, antique firearms, and firearms manufactured prior to the effective date of 18 U.S.C. Section 923 to be imprinted with an individual serial number. NJSA 2C 39-3 and 39-9 shall be enforced likewise. These guidelines shall be followed by all county prosecutors and all law enforcement officers in this state. So what New Jersey Attorney General Matthew Platkin is basically saying is, hey, we know how our law is written. It's really, really broad, and therefore when it comes to enforcement of this particular statute, we're actually talking about the federal definition of a firearm. Now, this is the product you get when firearm laws are written by people who have no clue what they're talking about. But the good news, New Jersey, and I know you don't get a lot of good news when it comes to Second Amendment issues, so cherish this moment, but the good news is that the largest gun grab in the history of the United States will now not occur in the state of New Jersey, not until your state assembly, of course, gets back into session next year. Listen, you may have more questions about this or anything else related to what's going on with your Second Amendment rights. If you guys do, you should know how to contact Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.